So in the Talmud, there are all kinds of dis- discussions about how to evaluate certain claims. In other words, there are some claims that by definition are more trustworthy, and other claims are less trustworthy. So if you have two claims, the Talmud will tell you what to follow. Now, this is very different than what we think of in American law, the secular law. In the secular law, how do you decide which claim is more trustworthy? You don't decide. There's no rule. It's up to the jury or it's up to the judge. And they tell the jury, you listen to both parties and you decide what you think is more trustworthy. So they're not telling you how to evaluate a certain claim. But the Talmud is different, and the Talmud has various ways of evaluating claims and saying some claims are better, some claims are worse. And we're going to have a case in point, which is right here, right now. And the general idea is it's in Hebrew and Aramaic. And the question is, what happens if there's bari v'shema? Bari v'shema means certain versus maybe. So in other words, there's a dispute. You make an absolute certain claim, and I defend myself with a maybe. So the general principle is that certain and maybe, which one is better? Certain. So that's the principle. Bari b'shema, bari adif. Aramaic, Hebrew for, if you have certain and maybe, certain is a better claim. Now, I'm going to give you a few cases where you would see if you agree or you disagree, but also remember, this is a general rule. It doesn't always apply. It only applies in certain cases, as all general rules. But let me give you an example just to warm things up. Seth comes up to me and says, Menachem, you owe me $10. That's an absolute claim. Now, if I say, Seth, I owe you nothing, that's an absolute claim. And the law in that case would be that I don't have to pay, because unless Seth can produce evidence. But if there's no evidence, if you want to extract money, Seth wants to extract money from me, you need evidence. But if you have a claim so that would be a claim of certain versus certain. David tells me I owe him $10. I say I don't owe you anything. We know what to do. So it starts getting interesting. What happens if somebody comes up to me and says, Menachem, you owe me $10? That's a certain claim of certainty. I say, I don't know. So I'm defending myself with a claim that is a maybe. So it's not an absolute certainty. So now the question is, what would you do? What would you think the ruling should be in that case? If it's a claim against a claim, certain against certain, follow certain. Then we know what to do. There's no other evidence. We understand that sometimes a claim of certainty is better, but in this case, think about it in this way. So you come to me and you say, I owe you $10. The claim is Yankel comes to me, Menachem, and he says, Menachem, you owe me $10. That's a certain claim. I say, I don't know, maybe I do, maybe I don't. I don't know. I don't remember. I'm not sure. So what would you do then? Would you say that the person claiming, the plaintiff, would have to produce evidence? Or you say, well, if you don't know, we have a certain case, we have a claim of certainty versus a claim of perhaps, of shema, of maybe the certain is more powerful than the maybe. So if anybody wants to jump in and tell me if you think that you would prefer the certain in this case, or just say, well, the plaintiff has no evidence, so let's just let's leave it at that. I shouldn't have to pay. If you have an opinion and you want to share it, and you're kind enough to share it, I would be very curious to hear.
I think that the maybe is more sincere, could be more sincere. So if you claim with certainty that you can question the certainty in this case.
Okay, so Vicky, you're saying something very interesting, but I'm going to counter argue. You're saying that
it's psychology of it.
Yeah, so you're going to the psychology. You're saying certainty. Well, the guy is saying he's not sure. At least he's not lying. If he's lying, he would say no. Okay.
Right.
Okay, but I'm going to count the claim because in the Talmudic law, based on the verse, you know the law of the partial admission. The law of the partial admission is biblical law, and the Talmud explains the logic, which is absolutely fascinating. So we're going off track a little bit, but it's important. So the law of partial admission would say that if somebody comes to me and says, Menachem, you owe me $100, if I deny it, I don't have to pay because the guy has no evidence. If I say I owe $50, I only owe $50. So then I would say, wow, believe the guy, he's honest. He could have said nothing. We said, no. We're a little suspect of this partial admission. Why are we suspect of partial admission? Because Vicky is right, taking psychology into account. And that is, okay, the guy's trying to be truthful. But on the other hand, we have another problem. There's another issue of human psychology. And that is that people, it's very hard, at least in those days, most people, to be a mensch, it's very hard to outright deny someone who did you a favor. So Seth gave me a loan of $100. I don't have the chutzpah, I don't have the audacity to tell him I owe you nothing. But I don't want to pay him back. So to calm my conscience, I say, you know what? I say I owe you 50, right? I soothe my conscience. And therefore the Torah says, in a case of a partial admission, Seth says I owe him 100. I say I owe 50. I have to pay you 50. But I have to take an oath, a biblical oath. I have to swear that I don't owe you the other 50. Because the Torah says I'm a little suspect of all of a sudden the sincerity person coming up with a partial claim. Because we're suspect that maybe I owe you everything, but I don't have the audacity to deny it outright. So if I apply that logic to this case, so you're right, Vicky, that the guy who says I'm not sure is being sincere, but on the other hand, I can make opposite arguments. Seth owes me $100. But Seth says I owe him $100. It's true. I want to deny it, but I can't deny it outright. So it's so easy to say, I don't remember. You go to court, right? Anytime there's a trial, nobody remembers anything. Why? They don't want to lie. I don't remember. I don't recall. The most common answer, I don't recall. That is a lie, of course. But the question is, psychologically, which a lie is easier for me to say, right? Human behavior.
Psychologically,
human behavior.
You can't bring psychology into law. Law is law.
Law is law. Part of Jewish law, and I started out, it's a little bit different than secular law. Part of Jewish law is trying to evaluate what claim is more true. Part of that process of evaluating what claim is more true is what kind of claims do people make? What kind of claims do people make, and what kind of claims is difficult for people to make? And that's very important into discussion of how to evaluate something that, when someone says something, how do you evaluate the truth of that? So part of that consideration, we're not talking about law. The law is absolute, but law has two parts. Law is if A happened, this is the law. That we don't need psychology. But the question is, what happens if two people come, each person makes a claim? Now we have to evaluate, trying to figure out the truth. It's again, remember that it's not clear that we know how to figure out the truth.
Suppose the person doesn't care about giving an oath, it means nothing to them that they give an oath.
That's right. So then
what do you do?
So then we can't solve all the problems. In other words, we can't get 100% situation. We have a situation in this world where there's evil and people are dishonest and people lie. And we can never get to 100% certainty that we are reaching the right conclusion. But the part of the legal process is to the best of our ability to try to figure out based on logic and based on everything we can bring to the table, is trying to figure out what's the best attempt to reach the truth. So let's go all the way back. Let's go back to our principle, Bari V'Shema, certainly and perhaps. So someone comes to me and says, Menachem, you owe me $10. That's an absolute claim. I counter with a perhaps. I say, I don't know. Now the question is the fact that I am not sure. I'm the defendant, I'm not sure. And the plaintiff is sure. How much weight do we give to the fact that this guy is sure and you're unsure? So if I ask you, forget about the guy, I ask you, said you have two people making an argument. And one guy says, I don't know, I'm not sure. Another guy says, I'm sure. So if you don't know, we'll find out. So if you don't know, your claim is weakened. Like, why are you here? In other words, what is your argument if you're not sure? Guy who says, sure, okay, I understand what you're saying. So that's the question that's the Talmudic question that comes up in many places. This case, Pari Vishem, certain and maybe. And because we're studying Talmud, you'll be happy to know that there's a debate. There's a debate. It's not clear. One opinion says the guy who says certain and the guy who says maybe, certain is stronger than maybe. End of story. So if Seth comes to me and Seth says, Menachem, you owe me $10. I say, I don't know. Maybe I do. Maybe I don't. I don't know. So the first opinion says, I have to pay Seth. What do you mean you don't know? If you don't know, fine. So if you don't know, so you don't have a defense, right? You can't show up to a defense. Seth pulls me to court. And the judge turns to me, what's your response? I don't have a response. If you don't have a response, pay. Right? So that's the same idea. The same idea is if you don't have a defense, you have to pay. But if you're not sure, then you don't have a defense. If you don't have a defense, you have to pay. That's one opinion. The other opinion says something very interesting. Yes, it's true that certain versus maybe, certain is stronger. However, it's not the only consideration. And there's another consideration. And the other consideration is, we mentioned earlier, if you want to extract money from me, the burden of proof is upon you. So the person making the claim has to bring a proof. And at the end of the day, the certain claim could be a certain claim, but the certain claim is not a proof. So in other words, if we just looked at this certain verse maybe, yes, certain would certainly be more powerful. But the other opinion says it's not the only issue to look at. You also have to look at what we call the chazaka. The money is in my possession. Somebody wants to extract money from my possession, they need proof. They don't have proof, they don't have to pay. So you see what I'm saying? Everybody agrees with the principle, but it's not clear that the principle works in every time because there could be other principles.
Maybe the person who says maybe he just honestly forgot.
Maybe, but you don't. That's fine. That's fine. So you don't know. But what's your defense? In other words, how do I know that I don't owe Seth money? If I say I don't, I don't. But if I don't know, then maybe I do, and he has a claim. So obviously, the guy's a trustworthy person. Seth is a trustworthy person. I should pay Seth, unless I say no, right? If I'm not saying I don't owe you, then why shouldn't I pay you? That's one way to look at it. The other way to look at it is you have a chazaka. The money is in my possession. If Seth wants to take money out of my possession, you need proof, and there's no proof. Let me give you an example. Let me give you a case where everybody would agree. There's $50 on the floor. Not in nobody's possession. It's not that someone says, I owe him money. There's $50 on the floor. There's no possession here. And one guy says, it's my money. And the other guy says, maybe it's my money. I don't know. Maybe it fell out of my wallet. Maybe, I don't know. In that case, everybody would agree. You give it to the guy who says it's his money.
They're both certain.
Now, if they're both certain, it's a different question.
No, but they're both certain. Even the guy
Who says, I don't know?
Because he's certain that he doesn't know.
Okay, so he does. Could he say?
They're both certain.
Does he make a claim? Yeah, he's right that he doesn't know. But does he make a claim? Is he certain that the money is his? I ask you. He's not certain. So why would I give you the money if it's not yours?
But we're not certain the guy who's claiming that it's it really is.
So we're not certain. So I guess the logic is that's a good question. It's a good question. There's different theories of exactly how this law works. So one way to look at it is different ways to look at it. One way to look at it. We believe anybody who says anything until somebody else contradicts it, because the assumption is you're saying it's your $50. Why would I disagree?
Okay.
So we agree. We believe everybody. Unless there's two people contradicting each other, then we say, okay, so we can't believe either. We have to look at the evidence. So all I'm trying to say here is that if it's a case where nobody has possession of this $50, it's on the floor in the public domain. One person says, I know for sure it dropped in my wallet. The other says, maybe it dropped in my wallet. I don't know. Then all agree would say, you have certain, you have maybe, you follow the certain. This case is a little bit different because this case is, it's in my possession. The money is in my possession. Someone says, I know for sure Menachem owes him $50. That's a claim of certainty. I say, I don't know. But I don't know, but at the end of the day, it's in my possession. You want the money out of my possession? Bring proof. So that's the debate. That is the debate in the Talmud about certain and maybe. And again, even though in principle, we all agree, not we all agree, but the Talmud, all opinions in the Talmud agree that a claim of certainty is stronger than a claim of maybe. And again, why that is, there's all kinds of interpretations. I'm going to give a few of them. We just mentioned 1 to 7. That is that when you make a claim of certainty, we assume people are trustworthy. Someone comes before us. There's no reason there's no reason to question his authenticity and his trustworthiness. There's no reason to question his trustworthiness. So somebody comes up and says the $50 is his. We're going to trust him. Why not? The only time we won't trust him, there's a counter argument. But a maybe is not a real counter argument because maybe is not a contradiction. So that is the two opinions about what to do when you have certain and you have maybe, but against the certainty is the person saying maybe it's in his possession. Okay, so it's in my possession. If it's in my possession, then even though my claim is maybe, some people would say, yes, certain is better than maybe, but certain is not better than maybe when the money is in my possession. If the money is in my possession and you want to extract it from my possession, you want to make me pay the other guy back, then I would have to bring proof. Then you would have to bring proof.
Suppose there's no proof.
There's no proof the money stays where it is. You can't, right? That's the idea. Possession is very powerful. Even in American law, we say, there's a phrase that says possession is 9/10 of the law. In other words, if you have possession and there's no proof, I come and say, Seth, something that you have is mine. Your watch is mine. You don't have to prove that the watch is yours. I have to prove that it's mine. And if I can't, you keep it because you're in possession, right? So the same thing is in Jewish law. Jewish law may be even stronger than that. But the bottom line is, so that is the discussion here about certain versus maybe, which is very interesting. I think is interesting. So that's the two sides. What is the halacha? What is the law? The law is, again, there's qualifiers and it's not in every case, but the law is that even if there's a claim of certainty and maybe, even if there's a claim of certainty and maybe, that's not strong enough to extract money from the person who has it. So if someone approaches me and says, Menachem, you owe me $100, and I say, I don't know if I owe you $100. I don't have to pay you. Why? Even though you're saying certain, I'm saying maybe. And the principle is that in theory, certain is better than maybe. But there's the factor here that it's in my possession. And if it's in my possession and you want to take money out of my possession, it's not strong enough. You can't take money out of my possession, even if you're saying certain and I'm saying maybe. That's the halacha, that's the law. And once we did the law, now we'll see in Maimonides, we came to this in a roundabout way, because Maimonides talks about a case where there's just a claim and one is certain and one is maybe, and we end up with following. We have to follow that. We don't. Even the person who says maybe does not have to pay, even though it's a maybe claim, because he's in the possession. So before we read the law inside, I wanted to give you a little bit of background of the logic behind the law. This is a big topic. We could literally sit on this a little bit longer, and we can talk about all the various theories of why this law applies. I'm happy to, why this logic applies. I'm happy to do a little bit of that. But maybe we should do the law inside. And if we have extra time, we'll do the logic. We'll do the logic. So far, I gave you two interpretations of what the logic is. One I said is that we assume we believe everybody unless it's a counterclaim. So when someone says a claim of certainty, we assume we believe him unless there's a claim that contradicts that claim. But in this case, there is no claim that contradicts, because a claim of maybe is not a contradictory claim. It's a maybe. It's not strong enough to contradict the original claim. So there's no reason not to believe the first person, person A, if person B is not even contradicting person A. You're saying maybe, well, maybe it's not strong enough. That's one opinion. Another opinion is that when there's a plaintiff and there's a claim, the defense has to defend themselves. If the defense does not defend themselves, then we rule with the plaintiff. In American law, if you get subpoenaed, if you get sued, and you don't respond, you don't hire a lawyer and you don't respond, what happens? It's called a default judgment. Automatically, the plaintiff wins. Why? I don't know if he's saying the truth, but you made a claim. You didn't defend yourself against it. So we go to the person. So the person to the claim wins. That's what it's a default judgment. So now the one way of looking at it, this is a modern way. It wasn't common. This is like in the last 50 years. And this interpretation of the Talmud is when someone makes a claim against you, you have to defend. But a maybe is not a defense. Someone comes to you and says, you murdered someone. And I say, I don't know, maybe I did, maybe I didn't. Right? You understand, with murder, you see the criminal trial say, sorry, it's very, very nice that you're not sure. It's very nice that you're honest, but it's not a defense, right? So the same thing goes with monetary issues. And the same thing is the same thing would be with monetary law. Within the law, I'm generalizing because it gets a little bit more complicated. And the reason why it gets more complicated is also a question, and this is what it comes down to. It also comes down to later. I don't want to get into it right now because this is sort of the next layer of law. What I told you so far is all true in the basic law. It becomes later, the later commentaries ask a question. They say, not all cases are made equally. Is it a claim that I should have known? Right? Was the expectation that I should have known? So Seth says, I owe him money. Well, why do I owe him money? Because he says that he loaned me $10 in shul. What do you mean, I don't know? You have to be able to say yes or no. You were there. But if it's a question that I wasn't there, then it's a different question. So you say, your cow, Seth comes to me and says, my cow ate up your lunch. Okay, it's very nice, but I wasn't there. I say, I don't know. Say, oh, you don't know. The fact that you don't know maybe should not take away from your validity of your claim because you had no expectation whether or not you should know. See what I'm saying? So even though Talmudic law says, yes, the law is that we don't, what did I say? The law is that we, okay, I'm getting a little complicated here. The Talmudic law says that if I have possession, you don't take it out of my possession. Because even though certainty is stronger than maybe, but in this case, even though certainty is stronger than maybe, but in the case of, even though certainty is more important than maybe, stronger than maybe, but in case of possession, the certainty cannot put out of possession because you need a proof to take it out of the possession. But I'm just saying that later on it gets a little more complicated because the question becomes of if I should have known, and if I should have known, then it becomes a little bit more complicated. Okay, that's for that.
How do they decide whether you should have known?
Well, they look at the claims. Seth, the plaintiff. What's the plaintiff's claim? Is the plaintiff claim a scenario that I should have known? If the claim is that something happened between the two of us, then if it didn't happen, I should know. Look, I know it never happened. If you come to me and you say, yesterday I took my car and I ran over your cat. Okay, that's just, maybe I didn't realize. You say I took my car and I smashed into your house. What do you mean? I don't know. I was there. The claim is that I was there. So I should be able to deny it. Right? That's one category. There's another category of things where the claim is something that I would never have known if I owe you the money. Even if I would have owed you the money, I wouldn't have known. What's a modern example? That's a little hard to find a modern example, but the Talmudic example would be an animal, because in those days everyone had animals. If my animal causes you damage, I'm responsible. But I can have a farm in Arizona, and you claim that my ox went out of my farm and ate your potatoes. I say, I don't know. Well, then the question is, even according to your story, there's no expectation that I should know, right? I wasn't there. How am I supposed to know? So I'm just saying that it gets detailed.
What about the theory of responsibility? That a person is responsible for, even if the cow is in Arizona.
Yeah, I am responsible.
You're responsible for that cow.
I'm responsible if you can prove that my cow caused you damage, and I'm responsible. But again, if you want me to pay you, you want me to cut you a check, you want me to write you a check, in the Talmudic language, it's called hamoitzi mechavera. You want to take money out of my possession, the burden of proof is upon you. So making a claim that my animal ate your potatoes is wonderful, but you would have to back it up with proof. Surveillance cameras. Oh, then I have to pay you. Or witnesses, then I have to pay you because even though I'm not present, but I'm responsible for the damage caused by my possessions. in most cases. Okay, so let's learn. Okay, we'll do the opinion. We'll do it in Maimonides, and then we'll see what happens. Again, we're learning the laws of borrowed items. So the case is a little bit more removed from the simple case of maybe and a certainty, but you'll see in a minute, it's really the same issue, it just plays out a little bit differently. Okay, so let's find it. Give me just one moment. Okay, so the case we're talking about is like this. We're talking about the laws of borrowing, and basically there's a difference between renting and borrowing. When I borrow something, the liability is all mine. When I rent, it's not always I'm not always at fault. Without going into all the cases again, the principle is that when I borrow something from you, I get all the benefit. So if I get all the benefit, I get all the liability. When I rent something from you, let's say I rent your ox. So I get some benefit, I get to use your animal, but you get benefit because the owner gets benefit because I pay you cash. So because because we both get benefit, so the renter does not get, in other words, the person renting, the person receiving the animal doesn't get all the liability. That's what we discussed last time. What happens if the question is, what happens in a case where we're not sure if the animal that was lost or stolen was borrowed or rented? If it was borrowed, I would be responsible. If it was rented, I wouldn't be responsible. What is the scenario where I don't know if the animal that was killed or stolen, I don't know what stolen, was borrowed or rented? So there's all kinds of cases. What happens if I come to you and I say, Seth, can I borrow your animal? And Seth says, I don't want to lend you the animal. I'll rent it to you. I say, please, could you borrow? They make a compromise. You have to say, you know what? 3 days a week, you can use it for a week, for 6 days. Monday, Tuesday, and Thursday, Sunday, Tuesday, and Thursday, it's going to be borrowing. You can do it for free, but I'm going to bill you for Monday, Wednesday, and Friday. See what I'm saying? It's 1 day rented, 1 day borrowed. And then I would have to pay you for the days that I rented. I won't have to pay you for the days that I borrowed. Or we say, can I borrow it for a day? You say, no, you want to rent it? We compromise. Say, you know what? I'll borrow for a half day and I'll rent for a half day. Or there's 2 animals. I say, Seth, can I borrow your animals? You say, nah, rent it. I say, 1 second. You know what? Okay, I'll borrow one and I'll rent one. I'll pay you for one. Then one of them gets stolen. So now that we have all these scenarios where an animal gets stolen, if it was rented, I'm liable. If it was borrowed, I'm liable. If it was rented, I'm not liable. But we're not sure if it was the animal that was rented or whether the animal that was killed, that was stolen, was it the rented one or the borrowed one? We're not sure if, or in the other scenarios, we're not sure if the animal was stolen on a day that I rented or a day that I borrowed, etc. So that's the question. And what's going to play out is it all depends on it. Well, what's going to play out here is that the plaintiff makes a certain claim and the defendant says, I don't know. I don't know if it got stolen in the morning or the afternoon. I don't know if it got stolen on Monday or on Tuesday. I don't know. So it's going to be a case of a certain versus a maybe. Go ahead, Vicky.
Oh, thank you, Rabbi. I don't know if that's a real scenario, but the scenario is kind of problematic because why do you want to pay for 1 day and not pay for another? Why don't you negotiate a lower price? Because in that case, it's going to be easier to determine.
Well, I don't know if it's in a real case or the principle is real, but I would say that some people don't want to lower their price, right? Because what happens if everyone hears that I'm renting for $50 instead of $100, then the other people are going to ask for the same rate. So I say no. I don't lower my rate. My rate for rental is $50, is $100. You want a favor? I'll do you a favor. Not everyone's going to come asking for a favor because not everybody has that relationship. So I could see a scenario where I'd rather rent it to you I'd rather rent it to you, but not lower the rate. And in addition, I'll tell you something else. My rate is $100 for renting. I don't want $50 for renting. The point here is, if I'm giving it to you as a loan, at the end of the day, if I'm loaning it to you, I have peace of mind that if it's going to get lost or stolen, you're going to be responsible. So I would not. You see what I'm saying? There's a benefit. Let's say I say on Sunday it's a rental, on Monday it's borrowed. I have peace of mind because Sunday I'm getting the full price, and on Monday, at least you have the full liability. Whereas if I say $50 a day for both days, I'm getting $100, but I'm getting no liability. I'm getting no liability insurance. But if I rent it to you, it's like I bought liability insurance. So you see what I'm saying? I got 2 days. If I rent it to you for 1 day and loan it to you for another day, I got $100. And then I have a full day of liability insurance. That's a deal. But if I gave you 50 for Sunday and 50 for Monday, then I will only walk away with $100, but no liability insurance, no day of liability insurance. So I see a scenario where I wouldn't want to lower my rates, because if I lower my rate, then I'm not getting the protection of liability because the renter is not liable, and I'm not getting enough money for me to forego the rate. So whatever you do, never lower your insurance rates. You want to do someone a favor and rent it and loan it to him, that's okay, because on one hand, you're not getting any money, but on the other hand, you're getting protection.
Yeah, thank you. Yeah, that makes sense. But maybe for dispute resolution, it's going to be easier. Right. But
That's true. Okay, so I'm just going to read this halacha, the law, once quickly. We'll see how. Again, the main thing was the discussion to lay it up. Let's see what happens here. So I'm reading chapter 3, verse 3. The following rules apply when a person borrows a cow from a colleague. The animal dies. Now, do I have to pay? Well, it depends. Was it borrowed or was it rented? And a dispute arises between the owner and the borrower concerning the circumstances of its death. For example, he borrowed it for a half a day and rented it for a half a day, borrowed it for 1 day and rented it for 1 day, or he borrowed one animal and rented another, and one of the animal dies. The owner says the borrowed animal dies, it died on the day it was borrowed, or it died during the time it was borrowed. You see what I'm saying? The owners keep saying, the owners want to say the damage occurred when it was borrowed, so the borrower would be liable. And the borrower says, I don't know. Right? Oh, you don't know. So what do we do then? We follow the principle. When a person desires to expropriate property from a colleague, the burden of proof is upon him. Right? So we don't say that the plaintiff has a certain claim, is claiming certainty, and the defendant is saying he doesn't know. We don't say you follow the certain versus the maybe, because that's true that's true unless one of them has possession of the funds. Right now, the defendant has the money, and the plaintiff wants to extract money from the defendant, and therefore a claim of certainty is not enough. You would actually need proof.
Suppose the cow has escaped the responsibility of the borrower, then he still has borrowed the animal.
He would still be liable because a borrower is responsible for everything, even if it's beyond his control. That's the trade-off. Because you see, you think about the liability. That's the law in the Torah. The law is like this. There's basically 4 general categories of borrowing: paid guardian, unpaid guardian, renter, and borrower. And the way it breaks down is depending on who gets the benefit, that's the person who gets some degree of liability. And because when I borrow your item, you get nothing, and I get all the benefits, therefore I get all the liability. So even if something happens, it's out of my control.
I'm still getting benefit from it.
We're splitting benefit. So we're splitting benefit, and therefore, some cases, if it was lost or stolen, if it was lost or stolen, if it's a case that I could have been responsible. Actually, it doesn't say lost or stolen. It says died. Yeah. If it was lost, because it's true. If it was lost or stolen, actually, I retract. If it was lost or stolen, the renter has to pay. But if it died out of my control, if the animal died, then the renter does not have to pay. The borrower would have to pay.
That's inconsistent.
No, it was splitting the difference. The renter, when I rent something, I am responsible for things that are in my control, but I'm not responsible for things that are out of my control. If I borrow, I'm responsible for everything, even if it's out of my control. The animal had a heart attack. Not my fault. I didn't do anything wrong. I still have to pay. Why? Because since I'm the borrower and I get all the benefit, therefore I get all the liability. The renter, you split the difference. This renter, because you're the owner, you're getting payment, and I'm getting usage of the animal. Therefore, we divide the liability, and we say that if it was stolen, if it was lost or stolen, that's my fault. I should have protected it better. But if it died, then I'm not liable because the thing died. What do you want from me? So now the question becomes, we don't know what happened. The plaintiff says the rented animal died on the day that it was rented, in the hour that it was rented. The other guy says, I don't know. So the law is going to be, we don't extract money. It's not enough. I don't have to pay. Why? Because a certain claim versus a maybe claim, a claim of certainty versus a claim of maybe is not strong enough to make me pay and take money out of the possession of the defendant.
Suppose
Go ahead.
they have a rental agreement, but it's not like a written agreement.
Yeah. So we're assuming, that's a good question. So we're assuming, I'm going to stop here. We're assuming that we all agree on the facts. If I deny that it was ever rented, I deny it's your animal, then we have other questions. But let's say either I agree, either because I'm honest or because there's an agreement. So we're not denying those facts. If you deny those facts, then we have other issues, then we have bigger issues, right? So I agree that for one day I rented and one day I borrowed. I agreed to that. You also agree that one day I rented and one day I borrowed. You don't claim it was rented always. So we agree on the facts. The only question is, when did the animal die? Here, we disagree. You have a claim of certainty. You say it died on the day that it was rented. I say, I don't know. Now, if I say, no, it died on the day that you say it was died the day it was borrowed. And I say, I don't know. So the one Talmudic opinion would say, if you don't know, if I don't know, then I have to pay you because I don't have a counterclaim to your claim. But the law follows the opinion that says, no, I don't have to pay because the money is in my possession. And the plaintiff wants to take money out of my possession. And you can't take money out of my possession unless you have proof, even if your claim is certainty and my claim is a maybe. So that's the story in short. A lot more to say about the subject, about Bari and Shema, certain and maybe. But I think today was a little bit of a taste. And we learned a half a piece of Maimonides, so that's good too, half a section. So I think that's good to keep the brain sharp, keep us on our toes and keep us studying Torah and in line with the logic of Hashem. Okay, so thank you all for joining. Have a wonderful day.
Thank you, Rabbi.
Take care.